heard appeal in the matter of Say Stonehenge World Heritage Site Limited and the Secretary of State for Transport and others.
Yes, Ms. Graham.
Good morning, my lords. Yesterday we were looking at the decision letter on alternatives. Before I take you back there, I just wanted to take you to Mr Gilmore's witness statement in Core Bundle 3. Page 167.
Yes.
And they're starting at paragraph 39 under the heading Consideration of Alternatives. You have Mr Gilmore's explanation of what officials did with respect to alternatives and the material they looked at.
Which paragraph?
Paragraph 39 onwards.
Thank you.
I'd invite you to read paragraphs 39 through to 44, which is the section on alternatives. But just to highlight a couple of points.
Yes.
Paragraph 40, the second sentence explains that officials considered that in light of Mr Justice Holgate's judgment in Stonehenge 1, officials considered that the two alternative tunnel options were the most important and relevant alternatives.
Yes.
And you'll see the reasons why he concluded that they were the most well-developed alternatives presented, and other alternatives were assigned less importance. The following paragraphs then go on to set out what it was that officials looked at, including submissions from statutory consultees, including Historic England. That's paragraph 42.
No.
And over the page at paragraph 43, you have an explanation as to what officials looked at when considering route F10, with reference to the examining authority's report and the documents signposted in the examining authority's report.
Yes.
The representations from route F10 in response to the statement of matters from the Stonehenge Alliance were also considered. And then paragraph 44, just a signpost to the decision letter that we will come to shortly. And an explanation that route F10, this is the end of the paragraph, and the other routes were not specifically identified as mandatory material considerations in Stonehenge 1, and therefore they were considered in less detail.
Yes.
Going back then to where we were in the decision letter yesterday afternoon, we were at Core Bundle, page 646. Sorry. We were at Core Bundle 644, my apologies.
Yeah.
Looking at paragraph 217. And we left off looking at the specific point that the Secretary of State had recognised that he had disagreed with the applicant's position on less than substantial harm, and so had considered alternatives with reference to his own conclusions on less than substantial harm in the following paragraphs. That is then the process that is carried out in paragraphs 218 through to 228. And in those paragraphs, which again I would invite you to read, but I won't read them out to you now, what the Secretary of State does, what the Minister does, is looks at what is the same and what is different as between the two tunnel options and the scheme, with a particular focus on heritage, where he looks at the Western Portal and identifies the assets affected by the scheme and explains that they wouldn't be affected in the same way by the tunnel options, but different assets would be affected.
Yeah. Is there a map that shows these alternatives actually?
There is, that would be in Core Bundle 1, sorry, Supplemental Bundle 1.
Yeah.
where my decision to get A5 bundles comes back to haunt me, because the writing is very small. But
Yes.
there are maps provided, I think, with the environmental statement starting on page 200.
Right. Yeah.
That's the scheme, I'm told. It may assist Mr Taylor, who may well be on top of the maps more than I am, could take you to those. Really?
Right.
142, I'm told. Thank you.
142 in the same
142.
same bundle.
Yeah, same bundle. So that's 142 is route F10. 140
Yeah.
is the tunnel and indicative portals. Still struggling to put my finger on the longer tunnel options, because this is the...
Well, they emerge further down towards Long Barrow, don't they?
Yes. So those...
And what was the length of the other two options?
That's in the decision
So we look
letter.
at page 139, does that help us?
So that's the scheme tunnel is 2.9 kilometres.
Yeah, that's 2.9, but then
The longer tunnels,
route options 442 tells us about route options incorporating 4.5 kilometre tunnels, which I think from recollection was the longer tunnel that has been considered on previous occasions. So my memory may be failing me there.
we don't think there is a map in the bundle, but the length is at 138 of supplemental bundle,
Yeah,
and that is the 4.5 kilometre tunnel.
yeah. So yes, so that's longer by some 1.6. Is that right? Kilometres. Right, yes.
Just to show you an example of the exercise that the Secretary of State went through, if you look on page 644 at paragraph 218 and read that paragraph, that shows the comparative exercise of looking at the differential heritage impacts from the cut and cover tunnel.
Could you give me the reference then?
218 of the decision letter, page 644 of the core bundle.
Yeah.
Just to highlight the conclusion at the end of that paragraph over the page, the benefits of the cut and cover tunnel would therefore avoid some of the elements that give rise to less than substantial harm that would benefit attribute 5, but it will not avoid all of them, and that was the overall conclusion on these tunnel alternatives, was some of the less than substantial harm would be avoided, but not everything. Paragraph 219 and 220 then set out the other environmental effects of that tunnel alternative, including significant adverse effects that would arise from that alternative that wouldn't arise from the scheme. 221 then explains the difference in terms of cost for the cut and cover extension, which is £392 million, and an additional 12 months for the construction programme.
Yeah, that's the 400 million figure, rounded, that we saw the other day.
I think the thought for the 400 million figure you saw the other day was the cheaper
F10.
cost.
Oh yes, I'm sorry.
Yes, that's the
no,
cheaper cost of F10.
That's a
isn't it?
different
That's a
figure.
different cost. For the bored tunnel, you get the difference in cost and time at paragraph 227. So that's an additional 466 million. Additional time required to develop the design and apply for a DCO of at least 2 years and up to 4 years, as well as an additional 12 months for construction. So a delay of many years.
Yes.
And then you have the overall conclusion on the cut and cover tunnel. You have that at 222, and for the bored tunnel you have it at 228. 222 for the cut and cover tunnel and 228 for the bored tunnel. And for both options, the conclusion was that having carefully considered the relative advantages and disadvantages and giving great weight to the potential reduction in harm to heritage assets, including the AOUV and the WHF, it was not considered that the significant extra cost together with the delay was justified to achieve the level of reduction of harm and any other benefits.
Yeah.
Pausing there, the claimant under ground 8 of the judicial review, the appellant, has challenged these paragraphs on the basis of inadequate briefing, and what is said is that there's no evidential basis for the conclusions in DL 217 to 218 and 224, and that is paragraph 38 of the appeal skeleton. It's not entirely clear what additional information the appellant contends should have been provided under ground 8. But it appears to be that there was no asset-by-asset comparison of the heritage impacts of the longer tunnel alternatives. And I have 2 points to make to that. First, as a starting point, there's no legal requirement for there to be any such asset-by-asset comparison.
Maybe the helicopters unfair
Legal
competition.
difficulty.
Can you just say that again?
There's no legal requirement for an asset-by-asset comparison when looking at alternatives. That's point 1. Point 2 is a comparative exercise was carried out, and that's the exercise I've just taken you through, where the Secretary of State, in the knowledge of the conclusions that had been reached on the impacts of the scheme, identified the particular differences and the different impacts. Those points were raised in the judgment, were raised in the court below, and given very short shrift in the judgment at paragraphs 175 to 177. And that's at page 210 of the core bundle.
Do you want us to look at that?
Yes, please. Page 210. Starting at paragraph 175.
Yeah.
And the points made there are, point 1, there's no freestanding ground of judicial review in respect of these longer tunnel alternatives. Secondly, at paragraph 176, the point I've just made that there's no legal requirement to go through asset by asset and look at the different impacts. And finally, we've already looked at paragraph 177.
Yeah.
The law does not require anything more than brief summary judgments.
Yeah. And you would commend that analysis for to us, would you?
Yes, my lord. further point made in the appeal skeleton at paragraph 65 and 76 to 78 is that there was no expert input on this topic from Historic England. But
The references in the skeleton.
65 and 76 to 78.
Yeah.
But Historic England did provide submissions on the topic of alternatives in response to the statement of matters, and that's at Supplemental Bundle 3, page 30.
Yes.
So that's where their submissions start. The relevant section I wish to draw your attention to is at section 7 on page 35, concluding remarks.
Yes.
And there, Historic England says it's reviewed the further information that had been provided by the applicant as part of the redetermination process and remain confident of the scheme's potential to deliver benefits for the historic environment. You don't see Historic England saying, we need to give you expert advice on the longer tunnel options, and you don't see Historic England saying, we prefer the longer tunnel options, and that is obviously a factor that the Secretary of State was entitled to take into account. So Historic England had a full opportunity to make whatever points they wished to make on alternatives and heritage impacts of the various schemes under consideration, and that was their position.
So what their position on alternatives then, if you like, in a sentence would be?
They weren't advocating for them and had not identified any lack of information that they said needed to be provided.
Well, is it paragraph 2.8? I mean, section 2 is their observations on alternatives, and the last sentence says Historic England considers that while no new HIA, Highways Impact Assessment, presumably has been undertaken, the information they've just referred to, sufficiently addresses the new inclusion on the HER. What's the HER? When's the term?
Historic Environmental Record.
Oh, right.
So that point was a question that had been raised during the Rule 20 process, which was, well, have you included all assets you need to include in the baseline, and have they all been assessed?
Oh, I see. So it's a slightly different point then.
It's a slightly different point, but Historic England is saying there's no heritage impact assessment for each alternative, but the baseline's correct for having looked at all the things that could be affected by the scheme. So you're right, it's a slightly separate point. But again, had they wished to say, we think you should have an HIA for every alternative, they had the opportunity to do so. So the alleged absence of expert input, first of all, isn't there, and secondly, is not a reason to reopen the examination, because an opportunity was given for that input to be provided.
Right.
That is the end of the longer tunnels, unless you have any specific questions that I can assist you with.
No, thank you.
So back to the decision letter.
Can we put those
You can put
materials away?
you can put all three away.
Yeah.
The consideration of route F10 starts at paragraph 229 of the decision letter. So we're back in the core bundle on page 647. You were taken by the appellant to paragraph 230, but the analysis starts in the preceding paragraph.
Mm.
And I would invite you to read those two paragraphs together.
Yes.
At the end of 229, having considered the representations in support of each of the options and the applicant's assessment of each, the Secretary of State agrees with the applicant's decision not to progress any of these alternatives for the reasons given, and as further set out below. And paragraph 230 is then additional reasons why route F10 is not to be preferred, focusing on heritage impacts. Paragraph 230 specifically refers to one of the documents produced in the examination by National Highways, which is Rec 2024. That document appears in Bundle 1, Supplemental Bundle 1, and the relevant paragraphs are referenced at page 283, but it's part of a much longer document.
So, volume 1?
Volume 1. If I take you to the first page of that document, it's page 256 in Volume 1.
Yeah.
This is the applicant's response at deadline 2 of the examination to written questions on alternatives. My Lord Justice Lewis asked yesterday, was the applicant asked questions about alternatives? This is the document.
Yeah.
So this whole thing contains all the questions on alternatives that were asked for deadline 2 and the detailed responses of National Highways. A number of questions were asked about route F10. The specific passages referred to in the decision letter are at page 283 in response to a question asking for detail about the disadvantages of route F10, full justification for the decision explaining the perceived greater overall environmental impact and how the factors were weighed in the balance. And it's under the heading Cultural Heritage. You have an explanation there of this point that you debated with Mr. Wolfe about the intersection with the western corner of the boundary of the World Heritage Site, and you have the applicant's case there on that, which is then signposted in the decision letter and summarised.
It says, 21 says, the F10 route circumnavigates the southern side of the World Heritage Site and avoids direct physical adverse impacts on the World Heritage Site. It's noted, however, that the F10 route is directly adjacent to the WHS boundary line in the southwest corner. And it's likely that direct physical impacts to the southwest corner could not be avoided. So that's their position.
Yes, and you see that summarised in the decision letter.
Well, it's word for word, really. They just take it from there.
Paragraph 22 is picked up in the decision letter, isn't it? Paragraph 22 is picked up in the decision letter where there's a reference to affecting as yet unidentified heritage assets.
Yes, exactly. And over the page there's more. So paragraph 23 is the details of the other barrows which contribute to outstanding universal value, impacts on the Winterbourne Stoke Barrow Group, and paragraph 24, the construction of F10 would introduce a new dual carriageway trunk road into a rural landscape that includes a number of historic villages that are designated as conservation areas and or contain listed buildings. And there's a list there.
Yeah. So you say that 21, is it all of this section then, 21 through to 27?
21 to 24 are the matters specifically referred to in the decision letter, but the whole section was looked at by officials.
Yes, it's 21 to 24 that's referred to at 230, isn't it?
Yes.
Right.
And that's a further example of in support of Mr Fleming's submissions yesterday about having been specifically signposted to the document in the decision letter. That's another example.
Right.
The issues around Route 10 and Ground 2 of the judicial review were dealt with at length in the judgment. And that's where I would like to go to next. So it starts at paragraphs 179 at page 211 of core bundle.
Do you want us to put away REP 224?
You can. Mr Taylor may have more to say about it later. That's all I need it for.
So yes, judgment 179.
So that's the beginning of the analysis on ground 2, and it runs over a number of pages to paragraph 197. Our short and simple submission is that's all commendable, legally accurate, and an accurate summary of what happened in the High Court, and so we rely on it. Just to put a bit more meat on the bones as to the history of Route F10 to aid your understanding, at paragraph 181, Mr Justice Holgate sets out the history of Route F10 and how it was considered in the examination with references. In particular, at 5.4.11, the examining authority looked at specific parts, or referred to specific parts of the interested parties' technical appraisal report and also the environmental statement, and provided further information and explanation in response to written questions. The Stonehenge Alliance's position is also summarised there. In the examination, it challenged one reason given by the interested party for rejecting Route F10.
Where are you?
I am at the very bottom of page 211.
Thank you.
The essay challenged one of the reasons given by IP1 for rejecting F10, namely an increased potential for rat running through villages. And then there's a summary there of what the examining authority report says, including cross-references, including to Rep 2024 that we've just looked at. The judgment then runs through more of the history, starting from the statement of matters at paragraph 182. One point on rat running, that was the Stonehenge Alliance's case in the examination. Had it wished to challenge more of the detail of the interested party's position and some of the points it seeks to raise now about an absence of environmental information, that could all have been done in the examination, and the examining authority would have looked at that and put it in their report, but that was a choice at the time for Stonehenge Alliance not to do that.
Yeah. So can we, perhaps while we're pausing, just get the main submission here? Do you want just to spell that out for us?
The main submission is that the judge went carefully through the history of Route F10, the points raised by the claimants in the ground of judicial review and dismiss them all as unarguable, and in my submission there's no error in his analysis.
From recollection, it seems so long ago now, the 2 points they were making is that there would be benefits or less harm from putting the road round the south, and it would cost £400 million less than the proposed option. Are those dealt with in the judgment specifically?
Yes.
Or,
So on the question of costs,
yeah.
that's at paragraphs 190 to 194.
Oh, yes. Thanks.
And you'll see there, the point was only briefly made in Stonehenge Alliance's submissions. That's paragraph 193. And the Stonehenge Alliance's point to the panel recorded in the examining authority's report at 5.4.36. They'd already made the point that Route 10 was cheaper. Just to give you those references, there are actually two references in the examining authority's report to F10 being cheaper, and so the Minister was aware of that point. We need to go into supplemental bundle 1 at page 16.
16.
It's paragraph 5.4.36, which is the paragraph that is being referred to in the judgment, where there's a reference to a reduction in costs and the point that the reduction in benefits matches the reduction in costs. So the benefits of the scheme reduce in tandem with the reductions in cost if you go for route F10.
5437.
36.
36, sorry.
5.4.36.
Right.
So the Minister knows there that it's cheaper. There's another
It's
reference.
not easy for the outsider not steeped in this to understand that sentence. It contends that the economic analysis, so Stonehenge is saying that the analysis doesn't support dropping off 10, since the reduction in benefits broadly matched the reduction in costs. Are they accepting or not accepting that there's some lesser benefits, but nonetheless it's still £400 million cheaper? Or how is that sentence meant to be understood by?
I think the Stonehenge Alliance were saying that exactly that, my lord, that they accept that there's a reduction in benefits, but also a reduction in costs.
So it wouldn't be, in inverted commas, such a good thing, but it'd be good enough and it's a lot cheaper.
Well, the only point they're making there is it was rejected too soon and should have gone to public consultation. They weren't, as you can see from
They weren't advocating, yeah.
5.4.37, they
I
weren't
think
advocating
from
for
the
route
reaction
F10.
to your left, what you just said about what SA was saying is not uncontentious.
Noted, my lord. I'm looking at the summary. I'm sure it
Yes.
will be dealt with if it needs to
But
be
you were
dealt with.
extrapolating back to what their case was, and I think that's where the disagreement came.
Well, it's summarised, and I believe it's summarised accurately, and no issue has been taken with it in 5.4.37, which is that they weren't at that time advocating for F10. Their point was it was dismissed too quickly and should have been presented as an option in public consultation.
Yeah, I mean,
I'm getting a nod now.
I think they were saying, well, good, you're getting a nod, perhaps I better not disturb the nod. But the real thrust of it was it hasn't been considered whether the balance of benefits to harm, given that southern route avoids the, if you like, the central part of the World Heritage Site. That hadn't been gone into and should have been gone into. That's what was really being said.
That's the point, yes.
Yeah, we're still getting nods.
Still
So
not,
that's-
yeah. At least for the purposes of...
that was their case.
Okay, at least for the purposes of putting it to public consultation, so getting through that next layer of sifting
Yeah.
in the
But
options
they're
process.
saying that it wasn't grappled with. is what they're saying. I think you're submitting that it was sufficiently grappled with, and that's maybe the issue for the court.
It didn't need to be grappled with, which is what
Right.
the judge said in the judgment, but also it was grappled with enough.
Yeah. All right.
There's another reference on cost, which is at 5.4.53. And that is at page 19, and that's a different interested party, the Council for British Archaeology, there, referring to UNESCO's position. The second sentence, it states that UNESCO had also previously drawn attention to other available options, such as the surface route to the south, which would be much cheaper, but have been inadequately assessed or compared for costs since the proposed tunnel was lengthened. So again, that point was there for the Minister to read because he had a copy of the examining authority's report.
Right.
The other point made by the Stonehenge Alliance was that it was overall better in heritage terms, and that is the point that they say hasn't been fully briefed or properly taken into account. If I just refer you back to the decision letter, we don't need to go there, but if you read paragraphs 229 and 230 together, what you see there is officials advising the Minister that it is National Highways' position that should be accepted, and that in fact there are impacts that weigh against preferring route F10 over the other routes, and that is paragraph 230 in the summary of Rep 2024 that we saw. The final point on that bit came up yesterday was the position of Professor Parker Pearson.
Sorry, just before we go any further, if we come back to 230, the balance seems to be struck. Does it really at the end of 230? Obviously you read that together with what goes before in 229 and the earlier part of 230. But the crux of it is, because of those potential adverse effects of route F10, the Secretary of State does not prefer it to the DCO scheme. And the potential adverse effects are those referred to in the earlier part of 230. Yes?
Yes.
And you submit, do you, that that's a straightforward, that manifests the exercise of a planning judgment, which is unimpeachable, you say?
Yes, precisely. Applying the principles in Langley Park, that the level of detail that you go into is very much a matter of planning judgment. Also, the ultimate judgment is planning judgment.
Right, sorry, you were about to go on.
I was going to take you to a few references in the underlying documents that officials looked at, just to flesh out what the other environmental effects were. You have my main submissions on route F10, which is that we rely on the judgment and we say there was no error. I can leave that detail to Mr Taylor, who I know was proposing to take you to those points.
Well, if you know that he's going to do it, then there's every reason not to do it yourself.
Exactly, and I think that would probably be a more efficient use of the time. So I will leave that to him. The only document I wanted to take you to was the environmental statement, and that's because a specific link was provided to the environmental statements in the ministerial briefing. So if we look at that very briefly, that's page 210 of, not the bundle, but in my notes, but I think it is, yeah, that's bundle, supplemental bundle 1, 210. And what you see there is a table setting out the stages of the options appraisal process. So stage 3 is a process of sifting. So route F10 made it to the pre-public consultation sifting. And the 2D corridors are scheme options, but optimised slightly differently. And then stage 4 is recommendation of the route options for consultation. So this is the point at which route F10 was sifted out. And you'll see just there a little summary of why it didn't make it, where it says on balance options D61 and D62 perform better than option F10 in terms of assessed impacts. Key differentiators were F10 being significantly longer route, which would pass through a largely unspoilt, high-quality, tranquil landscape with an additional crossing of the River Avon special area.
Where are you?
I am in the box stage 4, the first substantive paragraph. Second sentence starts key differentiators.
Thank you.
So significantly longer, pass through a largely unspoilt, high-quality, tranquil landscape with an additional crossing of the River Avon, SAC, so an internationally designated nature site. Much larger footprint, greater overall environmental impact despite having greater benefits for the WHS.
It's interesting because we've been focusing, understandably, on Stonehenge, and the argument has been this does less damage to Stonehenge and it's cheaper. And you think, gosh, why is he not doing it then? But you say the world is bigger,
Yes.
and there's not just Stonehenge, there's Wiltshire on either side.
Exactly, and that is a point that is addressed at length in the TAR, the SAR, and other underlying documents that were before the examining authority and considered by officials.
And it's not for us to do that, to decide whether Wiltshire versus Stonehenge is better. And does it matter if it's a World Heritage Site that little bit of Wiltshire, Stonehenge, is quite special? It doesn't matter, it's still a judgment subject to irrationality.
Precisely, especially in circumstances where the judgment that's not being challenged is that the harm caused by the scheme is less than substantial harm applying the relevant policy. So the balancing of that less than substantial harm, which this route can avoid, and it's controversial that this route avoids it, subject to that corner point.
And it would be cheaper, but the problem is there'll be damage elsewhere.
Other problems.
Yeah.
So this is, when you said earlier on why F10 didn't make it, that means why its assessment wasn't taken further. Is that what you mean?
Precisely, yes. So its assessment wasn't taken further by the applicant to public consultation when it was arriving at what it wanted to do to address the congestion problems, deliver the economic benefits, all of those benefits of the scheme that attribute to the need case.
Just because I don't know so much about these things, were the local communities represented below, and did they make submissions?
Not
For
in
example, that the Berwicks shouldn't have a road going part through them? Or?
So in the examination, I have to defer to Mr Taylor as to the extent of local force of opinion on alternatives. But through the process of examination, the local councils participated fully. Other interested parties participated fully. So what the judge of the court below sees and what you see is only the Stonehenge Alliance's position, because that's the claimant. They want to highlight the points that they were making, but there was a vast spectrum of opinion on all of this that was addressed through the examination, and no other judicial review that was issued at stage 1 or stage 2.
I mean, my working assumption, not being an expert in how these things are, would be that the local communities to the south, which would be affected by F10, would find compelling reasons why F10 should not be adopted.
It's not at my fingertips, my lord, but I have certainly seen that in the underlying documents at some point, and maybe I could dig that out for you. But
The point being that it's going to sound like a pun, but we are in danger of getting blinkered vision because we're looking at SA's position specifically.
Yes, my lord. But it was, as I said yesterday, it was all ventilated in the examination as well.
Yeah. Thank you.
Right.
So you'll hear more about F10 shortly, my lord, but those are my submissions on alternatives. You also asked a point of clarification when Mr Wolfe was on his feet about, well, what did the Stonehenge Alliance do in the redetermination? And their position was, I've checked this, that they were advocating for more than just F10. They were advocating for, in essence, anything but the scheme. So their submissions, which are in SB2 at 243, were that they had things to say about the longer tunnel options, things to say about Route F10, other surface routes, and non-expressway alternatives. And that featured briefly in the High Court. There was a suggestion that there had been a failure to properly consider non-modal alternatives, but that was dismissed, and you'll see it in the judgment that was dismissed. So that was their position. So pulling all of those threads together, just to conclude,
Yes.
the judgment is right. Recommend you read the relevant paragraphs, and in a way we have nothing very much to add to that analysis. It's clear that the Minister knew that F10 would avoid the less than substantial harm that he had found to the World Heritage Site, and that it was beneficial in heritage terms from the perspective of the World Heritage Site, subject to that point about the southwest corner. You've seen the exercise of planning judgment, the point being that the world was bigger. The Minister knew that Route F10 was cheaper, and there was no need for the Minister to be told any more, and as a matter of law he was perfectly entitled to rely on those brief summary judgments as set out in those 2 paragraphs of the decision letter.
Yes. Right.
Moving on then to ground 7, which is carbon. I think this can be dealt with relatively briefly given what was said on Monday. The issue in the High Court was whether the Minister...
Can you just remind us of what was said on Monday? It seems a long time.
I'm going to. I'm going to start with what the issue was in the court below. Because Mr Wolfe honed in on one particular point, which is the point I think can be dealt with briefly. The issue in the High Court was whether the Minister needed to be briefed on the reasons for the review of the National Policy Statement. That's dealt with in the judgment. We don't need to go to it just now. At paragraphs 244 to 256, Core Bundle 1, 225 to 227.
244 to
244 to 256.
Yeah.
And again, the one sentence summary of our position is the judge was right. The point yesterday, the point on Monday as it was expressed by my learned friend Mr Wolfe was that because the Minister didn't know the reasons why the NPSNN was being reviewed, he failed to carry out the exercise in section 1044 of the Planning Act, which is to ask whether the extant National Policy Statement should be departed from because of a breach of international obligations, those obligations being the Paris Agreement, and domestic obligations, those obligations being carbon budgets and the duty in the Climate Change Act to meet them. The reasons for the review that you were taken to on Tuesday, and just for your note, they are at...
Is this the 80% versus 100%? It is, okay. Is it
80%
coming back
versus-
to me now again? To lead to a breach.
Yeah.
So the position was, and this isn't controversial, that the NPSNN needed to be looked at again to check whether the policies therein were compliant with the new landscape for climate change obligations, being Carbon Budget 6, Net Zero, and also the department's own policies for decarbonising transport in the Transport Decarbonisation Plan, which is a departmental policy that sets out what it is DFT wants to do to decarbonise the transport sector. It's not a planning policy, it's a more general policy. And so the point is...
Sorry, it's not quite what you said. The reason for the review was the need to check whether the policies it contained were still appropriate in the changed landscape of the net zero commitment.
So that's...
Have I got that right, or am I missing the point?
That is right, is to review, check and, if necessary, update the policy.
Yeah.
And that's the framework that Section 6 of planning...
That's the framework where you've either got to change, or you've got to withdraw, or you've got to
stay the
leave
same.
it alone, or whatever it is.
Yeah. Exactly, Section 6.
And that's the policy for all road infrastructure
Road and
projects road and rail to which NP whatever applies.
Yes,
Yeah.
yeah. So not just this one paragraph
No.
that we've been focusing
Yeah,
on.
the lot.
There's a lot.
Mm.
And it pulls in the statement of need, and
Yeah.
it's a lengthy document.
Yeah.
And the point taken on Monday was this failure to carry out the Section 1044 exercise, and the simple response to that is that the Minister asked himself precisely that question with reference to these obligations and those policies, and concluded that he could still apply the policy. And I will just take you to the relevant bits of the decision letter that show that exercise being
Right.
carried out.
So the proposition is that the Minister asked himself precisely the question inherent in 1044. That's the point.
That's the point. And I will show you where the answers are, and then I will sit down and hand over to Mr Taylor.
Right.
So the carbon analysis in the decision letter starts at page 625. But you need to go ever so slightly earlier to page 623 and paragraph 116.
Yeah.
And there, in the first sentence, the decision letter sets out the correct statement of the law, so required to decide in accordance with the extant national policy statement unless section 1044 to 8 apply. That includes breach of international obligations or breach of duty under any enactment. And so the relevant question that Mr Wolfe yesterday said, on Monday said was not asked, was specifically in terms set out in paragraph 116. If you go over the page to page 625, paragraph 126, you have the decision letter setting out what the relevant international obligations are for the purposes of climate change. So that is the Paris Agreement, the point being made that it was ratified after designation of the MPS. That's translated by way of the carbon budget set in the Climate Change Act. June 2019, the government announced a new carbon reduction target for 2050.
That's the 100%, is it?
That's 100%.
Yeah.
Legally binding, it says in the last sentence, legally binding target for government to cut carbon emissions to net zero against the baseline. And then you have a little more in 127 explaining what that means. So again, all of the reasons for the review are expressly referred to there in 126 and 127. Don't think you were taken to these on Monday, but there they are. The Minister then goes on in the decision letter to look at the actual impact of the scheme against those commitments.
Yeah.
You see paragraph 132, which is just on the next page, 626, Secretary of State has had regard to paragraphs 3.8 and 517 of the MPSNN, and then a little summary of what they say. The impact of road development on aggregate emissions is likely to be very small. Need to be seen against significant projected emissions reductions as a result of current and future policies to meet the government's legally binding carbon targets. 5.17 sets out it's very unlikely that a road project will, in isolation, affect the ability of the government to meet its carbon targets. And the Secretary of State notes the examining authority's view that the proposed development's greenhouse gas emissions impact as a proportion of total UK carbon emissions would be negligible. If you're interested, paragraph 130, just at the top of that page at the end, sets out what the actual impact is. It's just those last couple of lines, less than 0.03% of total emissions in any 5-year carbon budget. That was the position as at the time of the examination and what the examining authority referred to as negligible.
And that is presumably largely because of the increment in road traffic attributable to these highway improvements.
Yes, and taking into account as well, although the assessment didn't take it fully into account, fleet changes over the operational lifespan.
Yeah.
So we are heading towards electric vehicles, zero emission vehicles.
So there's an offset for electrical vehicles
That's factored in, and
coming
the
in.
position improved as time went on, and updated assessments were provided by National Highways which showed actually reduction in carbon impact.
Yeah. We haven't looked at the whole question. I don't think we've looked at it in any detail at all of traffic flows. Where we came in, as it were, is the degree of congestion there is on this stretch of road, which is simply a matter of fact, I think, not a matter of to do. And the road scheme was put forward as a means of alleviating that congestion largely. Whether that leads to an increment in the quantity of traffic using the road in either direction is another question. We don't need to get into that. But all of that is subsumed in the calculation that leads to 0.03%.
Yes, and the point.
Is that right?
Yes, and the assessment carried out takes into account the traffic model relied upon by National Highways, which shows growth in traffic over the operational lifespan.
Yeah.
And that obviously is a point criticised by the Stonehenge Alliance, who are saying, well, actually, there's not going to be as much growth, so why do you need this?
Yeah.
So logically,
Yes,
their
because
position would also be not as much carbon.
The whole, if I can use the expression, direction of travel is in the opposite direction.
Yes. Yeah. So I was just showing you the 0.03%. That assessment was updated because the period of construction shifted. The opening year of the tunnel shifted. And you can see that in the decision letter at 137. And there you see that the estimates of impact actually go down. So it's 0.0078% of the fifth carbon budget, 0.0073% of the sixth carbon budget. So well below a threshold of 1%. And the applicant's position summarised there that there would be no material impact on ability to comply with carbon budgets or UK carbon reduction targets.
Yeah.
Paragraph 143, so skipping over, it's very lengthy and detailed analysis in the decision letter. Paragraph 143 just makes the point that I've made already, which is that the decreases are due to changes in traffic flows reflecting a different opening year, a different baseline because of changes in vehicle fleet mix, and also likely to be a conservative estimate. And the next paragraph, paragraph 144, makes the point that if you take into account the transport decarbonisation plan, which is that departmental policy I've already referred to, that will also help bring the assessed emissions down. And you see there at the end of that paragraph, there's a reference to the net zero strategy as updated. But it's against that background that the Secretary of State has considered the proposed development. So the Secretary of State took into account all of the reasons for the review of the MPSNN in the assessment of the specific impacts of this scheme with regard to carbon emissions. You see the outcome of that assessment on page 629 of paragraph 149. So there it is said, Secretary of State notes the scheme will result in an increase in carbon emissions, but doesn't consider that net zero means consent cannot be granted. Considers that as set out in 5.18 of the MPSNN, so that's the extant policy, it's necessary to continue to evaluate whether, amongst other things, the increase in carbon emissions resulting from the proposed development would have a material impact on the ability of government to meet its carbon reduction targets. As set out above, carbon budgets should meet the goals of the Paris Agreement, meaning a proposal which is compatible with 2050 target and interim budgets is consistent with the approach to addressing the severe effects of climate change.
You're reading in which paragraph?
I'm reading 149.
Yeah.
Secretary of State considers this aligns with the approach to significance set out in the IEMA guidance, that's the industry guidance on how to assess the significance of carbon emissions. Secretary of State considers that this approach set out in the MPSNN continues to be relevant in light of international obligations and domestic obligations related to reducing carbon emissions that have come in force since the MPSNN was designated. So that's the key sentence where the question is posed and answered. Do all of those things mean I have to change my approach? Answer, no.
And it is answered, having specifically referred at 126 to the change from 80 to 100%. So it's not easy to follow why the appellants are saying there wasn't an understanding of the reasons behind the change. It doesn't matter what document you can have it in. The key thing is that it's gone up by 20% and they knew that.
Exactly, and the ground of appeal is, well, the judge unlawfully filled in the gaps by reference to all of this analysis in the decision letter. But this analysis is exactly the question that the appellant says should have been asked. And it's very clear and it's very detailed. Just to complete the story, there are more references to the Paris Agreement and net zero throughout this section of the decision letter. I'll just give you the reference, paragraph 152. Is specific consideration of the impact of the scheme on Paris, net zero and transport decarbonisation plan. Paragraph 153 is an overall conclusion on the section, and the overall conclusion on climate impacts, which takes into account cumulative effects as well, is at paragraph 167 on page 634. And I'll just invite you to read that now.
Sorry, 634 what?
Paragraph 167.
Thank you.
Oh, shit.
Yeah.
So as as it was advanced to you orally on Monday, my lords, that's the answer to this ground of appeal. I don't think I need to say anything more. You were taken to the new policy, but as my Lord Justice Lewis noted on Monday, that was in draft. The judge looked at it and concluded that it would not have made a material difference, which was the Secretary of State's conclusion as well, because it still makes the point that schemes that give rise to residual emissions are permissible, and that those emissions can be managed in an economy-wide manner.
And forgive me if am I confused? The letter, the DL itself says, even if you apply the draft thing, it makes no difference.
And the judge agreed.
And the judge agreed.
Right.
So, my lords, unless I can assist you further, those are our submissions on the grounds of appeal.
Well, thank you very much, Ms. Gray. Mr. Taylor.
Oh, thank you. I adopt the submissions of Mr. Fleming and Ms. Grogan. I also adopt my learned friend Mr. Harwood's submissions from skeleton argument submitted on behalf of his client, paragraphs 15 to 46 in relation to grounds 5 and 6, appeal grounds 5 and 6. The submission that I make on behalf of my client is that none of the grounds of appeal identified that the learned judge below erred in law and that the appeal should be dismissed as a result. If that is not accepted, and the learned judge did err in law in some way, then my submission is that none of the grounds for judicial review are arguable and permission should be refused for them. And if that is rejected, then my submission on behalf of National Highways is that even if there is an arguable ground, there's no error of law identified in the grounds which reveals a basis on which the claim should be upheld and the claim should be dismissed. I'm going to work very quickly, I hope, through the grounds of appeal and add a few points if I may. I've got a few references for the court, but if at any point you've had enough of what I'm saying, please do hurry me along.
Well, can I just indicate one thing? You've got a bit of unfair competition from outside. It may not affect other people as much. So if you could turn the dial up.
I will indeed, my lord. Forgive me. I have one of those voices that it's a lower register and therefore doesn't carry all that far, but I'll speak
well, you can
up.
use your best falsetto as far as I know. It would be grateful if I could hear it.
Yeah.
That's a very, very tempting offer.
We are coping with, or contending with, the security arrangements, no doubt, for the state opening of Parliament today.
Indeed.
And that helicopter will be there for the duration, I imagine.
Indeed. So I'll keep my voice up. Appeal ground 1.
I'll just go, if you see me do that.
I'll keep my eyes open.
Thank you.
Appeal ground 1, I've got nothing to add, so that's easy.
Ground 1, nothing to add.
Yeah. Appeal ground 2, that's the one that seeks to extend the categories of mandatory considerations. In relation to this section 104.2d point, you'll have seen my submissions from the skeleton argument that it's submitted that the words of the section don't bear the meaning that the appellant contends for. I agree with my own friends, Mr Fleming and Ms Grogan, that they are a codification of the third category from Friends of the Earth, and that means that there is no obligation to work through every consideration to determine what might be relevant and important. And that's from paragraph 120 of Friends of the Earth, which you have been taken to already in the authorities bundle, tab 46 at 1973. I do want to just touch on the practicability of what is suggested by the appellants in terms of working through every single matter in a DCO application. You will have seen from my skeleton argument of paragraph 8, which we have in the court bundle at tab 3 on page 72, I made certain observations about the practicability of the submissions that have been made. And I just wanted to take the court to those briefly, if I may.
So,
This is a 72 core bundle 1. If there's a
you
duty...
mean supplementary bundle 1?
no, core bundle 1 is
sorry.
an isolated argument.
Oh, I see,
Paragraph
yes.
8D.
Which I've taken out anyway.
Yeah. It's called a respondent's notice, and then the paragraph 1 says the skeleton argument. That's the document, page 69.
Yes, that's right.
Yeah, okay. Why is it called a respondent's notice?
I think that's just an error.
Oh, all right, that's all right.
Because somebody who was typing it didn't change it.
Oh, right. Yes.
There's only one person who was typing it, and he's standing in front of you, so I can
But I don't need to worry about respondent's
That's why I
notice.
said what I did.
The point I'm making here is that if there is a duty for the Secretary of State to personally consider every matter raised by every party on every DCO, that would require the production of a huge document which identifies every single point raised by every single party, identifies whether that point is important or relevant, and presumably the appellant would contend provides reasons for a judgment as to whether that should be taken into account or not. Now that that proposition would mean that the EXA, which is the examining authority, which is required by section 74.2 to report and make a recommendation to the Secretary of State, would have to go through that exercise first. The Secretary of State and his team then get a report, but they then have to double check it. So they would then have to work through exactly the same exercise to make sure that not a single point is left out of account. And on receipt of that report, no doubt the Secretary of State personally, according to the appellants, then got to do the same exercise too.
Except that somebody's got to do it. That somebody's got to go through the material and say, oh gosh, yes, that looks a bit significant.
Yes.
But so long as it's done somewhere, 104 doesn't require it to be the Secretary of State personally.
Well, that's our submission, but I'm responding to what you said. As far as I've understood, it's on the other side. Now that in my submission, as I've said at F on page 73, cannot have been intended by Parliament, since it's entirely unworkable in practice. It has to be remembered that the 2008 Act was introduced to speed up the consideration and determination of applications for nationally significant projects after the very long inquiry at Tamworth 5, which I know that at least two of us in the room were involved in. I was there for all 525 sitting days. The Act was intended to speed up the process. What my learned friend's suggestion is that 104.2d should be interpreted in a way that would effectively bring the decision-making process to a crawl. It would also have potential consequences for challenge. If you can get to a point where you can make a decision, somebody somewhere will identify one point of their submissions that wasn't on the matrix that's been produced, and lo and behold, we've got a breach of statutory duty and a claim in the High Court.
And you'd have to do this, presumably, for every DCO. We had one 2 weeks ago at Manston Airport, I think.
Indeed.
And on top of that, there's the daily job of running the Department for Transport.
Indeed. And all of that is avoided but simply by interpreting 104.2d as embracing the third category from the Supreme Court's judgment in Friends of the Earth, which, in my submission, the words plainly bear. So that's that point. The next point was the Moseley point. Now, I think I've understood correctly that that is argued as a freestanding point to the section 104.2d point. It's, if the 104.2d is not accepted, then the Moseley point is wrong. And if that's right, and the points made by my learned friends are accepted, there is nothing that confines the appellant's submissions to DCO decisions. If you were to accept their submissions, then they would apply to all development control decisions. In other words, to town and country planning decisions as well. from the smallest development to the largest within that regime, and of course to all DCOs. And so that would mean that the exercise that I've just referred to, of having to identify every matter and consider it for its relevance and importance, and have a document that proves that you've done that and provides reasons, that would mean that that would have to be conducted in relation to every single application for planning permission in the UK, certainly in England. And if you don't do that, then obviously there's a risk of challenge in the High Court in judicial review. The administrative and practical consequences of that submission relating to Moseley would, in my submission, bring the planning system to its knees. The other aspect, though, here is that since the appellant's points isn't confined to DCOs by referencing the Planning Act, it would mean, in effect, that you're being asked to overrule Friends of the Earth. But there's been no submission made to demonstrate that Friends of the Earth is wrongly decided. And so in my submission, that is the end of the Moseley. I've got nothing to add on the points relating to the legal submissions about the sufficiency of evidence that Mr Penning has made. In essence, I'm with Mr Penning in his circle. Wherever we go, we come back round to Friends of the Earth. And the simple point as to whether all mandatory material considerations were taken into account and addressed in the decision letter, and indeed that was the approach of the judge in the court below, and in my submission he was correct. There are, in the appellant's skeleton argument, a number of matters that are given as examples that feed into the three categories that they identified under ground 2. At paragraph 25, they list a number of matters that go to the Moseley point, and if you reject that point, then you don't have to deal with those. I'm not going to spend any time addressing those matters. I've provided references in my skeleton argument to where the judge has addressed those issues. The only issue that he didn't address was geology, ground investigation and groundwater monitoring, and that's because although it was raised in the pleadings, it wasn't actually pursued before him. And so that's why he didn't address it, but it seems to be readdressed now. In terms of the references that I can provide you on groundwater, the Secretary of State determined that the scheme wouldn't give rise to any material impact on groundwater. You can see that in the decision letter at paragraph 33, which is in the core bundle tab 36, page 601. He's also looked at and identified certain benefits to the water environment in the decision letter, paragraph 105, which is at page 620 of the core bundle. He concluded that in terms of climate change adaptation to groundwater and flood risk, the scheme was acceptable. That's at the decision letter, paragraph 119, page 624. And he gave neutral weight to flood risk, groundwater protection and the water environment considerations at paragraph 183 of the decision letter, at page 638 of the core bundle. Moving on then from the Moseley point examples, paragraphs 26 and 27 of the appellant's skeleton argument, there are a number of points that the appellant says should have been considered when applying its proposed section 104(2)(d) approach. And so obviously if you reject that submission, then you don't need to consider those matters. The first point that's raised relates to why the Stonehenge Alliance said that the examination should be reopened, that the reasons they said it should be reopened should have been before the Secretary of State. So they're saying that 104(2)(d) bites on that issue. Now 104(2)(d) says that in deciding the application, the Secretary of State must have regard to any other matters which the Secretary of State thinks are both important and relevant to the Secretary of State's decision. So, in my submission, reasons why the examination should be reopened are not matters important and relevant to the decision, in other words, whether or not to grant the application, they potentially go to the exercise of the discretion to reopen an examination, but they don't go to the decision itself, and so cannot fall within the matters, even on my learned friend's basis, as falling in within the scope of 104.2d. And indeed, that is precisely what the judge below concluded, as we can see at paragraph 162 of the judgment. I'll just take you to that, if I may. It's page 16 of the full bundle, page 208. And at the very bottom of the page, the judge said, Mr. Wolf's point only goes at most to a possible exercise of discretion, not an obviously material consideration.
Another difficulty I've got with that, leaving aside the fact that they no longer are saying it should be reopened, it's not ultimately a matter for the Secretary of State. If fairness requires it to be reopened or dealt with in a particular way, then the courts will say so. Might be helpful and interesting to know what the decision maker says and why he says it does or doesn't require it, but it's not a matter of discretion for the Secretary of State, it's a matter for the court.
Yes. Yes, ultimately, if the court were to say, well, that's what the Secretary of State decided, but it was unfair, the court would intervene and...
Yeah, we couldn't say it wouldn't be a rationality test. Could he reasonably conclude it wasn't necessary? It would be, does fairness require this? And his views are a factor if he's got views, but no more.
I don't demur. The other aspects that were raised, there was a point about Stone Curlew, which I'm not going to trouble the court with. In relation to traffic forecasts, in my submission, the judge addressed that issue impeccably in his judgment. Paragraphs 131.
121.
131, my lord, sorry, forgive me, I'm dropping my voice again.
You are.
And 171, the references respectively are to the core bundle tab 16, page 202 and 210. You will have seen in particular that 2 points were taken, one about the use of central forecasts and one about the potential impact of COVID. Both of those were addressed by the judge in his judgment. I've got references that I can provide. In relation to the central forecasting point, in my submission, the most important reference that I can provide is a quote from the examining authorities report, which you've got at in the second bundle at tab 10 at page 165, and there's a quote there which identifies the traffic demand as such that there will always be a need to travel along the particular road corridor. I'll leave you to look at that reference.
There's a number of paragraphs on that page. What are you?
It's paragraph 335, and there's a quote from the examining authority report on page 166 within paragraph 3.3.9.
I'm sure this is terribly important, but what am I meant to do here? As noted by the Stonehenge Alliance? No.
Yes.
You introduced this as a bit of an exercise, and I'm looking at paragraph 3.3.5.
Yes.
And entirely missing the point.
If we look at 3.3.9, my lord, on page 166, the National Highways here explain that as demonstrated, the transport modelling undertaken, including the recent updates, fully accords with the latest guidance, refers to those, and that form the national methodology and national assumptions which MPSNN requires to be used. It says the transport modelling undertaken in support of the application DCO and the update since is therefore robust. Indeed, the examining authority's report concluded that, and then we've got this, the 5:17 to 67 and 68 from the report. The approach to the modelling is robust, it's followed the guidance, the evolution of the models taken into account consultation, to accept that it's fit for purpose, no substantive evidence of significant forecasting inadequacies or errors have been presented. And then this, the EXA acknowledges that travel patterns and vehicle usage may change in the future in response to climate change and technical advantages. However, in the EXA's view, there's a strong likelihood, the strong likelihood is that the A303 will remain an important corridor for motorised transport and that congestion will continue to occur at this location without the proposed development, even assuming the lower growth forecasts assessed in the transport assessment. Thank you. So that effectively deals with the point about uncertainty in the forecasts, because lower forecasts, central forecasts and higher forecasts were presented, and the EXA has made its conclusions about need by reference to that range. And indeed, in relation to COVID, you will have seen the assertions that the Stonehenge Alliance made about the effects of that. Of course, we're looking at forecasts for 2 years, for 2029, the assumed opening year, and 2044, the future operating year. So we're looking quite some time into the future. What Stonehenge Alliance didn't produce was any evidence on the degree of uncertainty associated with COVID, or how long that uncertainty would last in point of time. And they didn't produce any evidence that demonstrated that travel demand would be reduced either at 2029 or 2044 outside the range of uncertainty that had already been assessed by my client's national highways, in other words, beyond the low growth scenario. So that's all I have to say about that. In relation to F10, that's the next elements that are referred to in the appellant's skeleton arguments, paragraphs 28 to 34. Again, this is presented in the context of its submission relating to 1042D. But what is not taken into account in those submissions, in my submission, is the legal context for the consideration of alternatives, which you, my lords, have been taken to, namely that the extent of the detail in which the Secretary of State was to go into was a matter for the Secretary of State, subject to rationality, by reference to Langley Park in paragraph 53, which is in the authorities bundle of tab 18, page 538. In my submission, the decision letter in relation to F10 needs to be read with that in mind, but also on the basis that it's addressed to those who are aware of the issues. With that in mind, I'd also been taken to, in my submission, the 2 key paragraphs in the decision letter in relation to F10, that's to say 229 and also 230. I would just like to make one point, I think, if I may, about the relationship between those 2 paragraphs.
Right, so where are we going?
So we're in Core Bundle 1, tab 36 at 647.
Yep. Yeah.
And at 229, the decision letter turns to look at the 4 other route options. That's to say, the non-tunnelling options that were supported by interested parties and which were discussed. They include F10, as we can see. And at the very end of 229, the decision letter says, having considered the representations in support of each of these options and the applicant's assessment of each, the the Secretary of State agrees with the applicant's decision not to progress any of these alternatives for the reasons given by the applicant and as further set out below. So in my submission, the reasons in 230 have to be read alongside the reasons given by the applicant in relation to F10. And the reasons given by National Highways for not pursuing F10 were set out in numerous documents over a long time scale. I could spend hours delighting the court taking you through every paragraph, but I shan't, tempting though it is.
Well, no, you won't.
The scheme assessment report is from 2017, is within the bundle. You've got that at the first bundle, tab 4. I'm not going to take you to it, but that contains a précis of the scheme assessment process. What I am going to take you to, though, is the technical appraisal report.
Right.
And that is a document that we've got at tab 3 of the first bundle.
Right.
First supplementary bundle.
First supplementary bundle, yes. And that is a document that ran to over 200 pages, in which National Highways set out its appraisal approach. And you can see from the table of contents that it goes through a number of matters right beyond page 209. And the extract that you've got that deals with F10 starts on page 117.
Can I just check, is this the document that includes the reasons given by the applicant that's referred to in 229?
It is part of the evidence.
So we can assume the two are linked then?
Yes,
Right.
because this document led to the route selection. So this was a prior process before the route for the scheme was identified. That scheme was then subject to consultation and then found its way into the application documents for the DCO. So this is setting out the appraisal process, narrowing it down to the promoted scheme effectively. And at 7.5 we've got the analysis of the corridor F route options assessments, and you can see that 3 options were developed as potential options, and those were described and they're summarised. The extract we've got then jumps, but in essence you've got the end of the assessment of value for money of the 3 schemes. That's 7.568. There's then a financial case assessment, delivery case assessment, and we go into biodiversity, water environment, and all sorts of other matters. And then it's all brought together in the assessment process section in 18.3 at the bottom of 119. And there are a large number of matters that are considered, including noise that we can see in 120.
And just to be slow, I just need to marry up the 3 routes in 18.3.1 include the F10, do they? Because
yes, the 3 routes, we can see them. They're described in the table actually on 118. You've got F4, F5, and F10.
yeah.
And so
Oh, okay, F10 is there. Yeah.
So the cost outturn comparison table 7.6 above 7.570. You can see the most likely cost for F10 was 9.66 million.
Yeah, I see it now.
That's the figure that the appellants have used to do that calculation of the cost differential, for example. So then I was taking the court through just to look at the factors that were considered. So we saw there was noise on page 120, air quality at 122. We got to greenhouse gases at 123, and there's a comparison between the D options and the F10 option for greenhouse gases, and interestingly F10, because it's a longer route, gives rise to greater greenhouse gas emissions. Then landscape matters are considered, And in relation to F10 and landscape, we can see at the bottom of 124 a very large adverse impact was assigned to F10 as a result of impacts identified on the upper Avon Narrow Chalk River Valley character area, and it refers to at 18.331 to a range of slight to very large adverse changes along its length. As the route passes through the upper Avon Narrow Chalk Valley, it would be elevated and aligned against the grain of the existing landscape. This would be a highly visual and intrusive feature, and the potential effects would extend north and south some way along the valley due to the substantial height of the route over the valley floor being at complete variance with the landform, scale and pattern of the landscape. There's also a reference to large adverse effect on the Larkhill Chalk Downland area as well there. Then we get townscape is looked at, historic environment is turned to next, and I think paragraph 18.341 is a matter I should draw the court's attention to. That explains the mixture of beneficial and adverse impacts of F10 on designated and non-designated assets. The beneficial impacts would arise from the removal of the A303, and the adverse impacts arise from the physical impact of construction on assets outside the World Heritage Site, and the impact of the new dual carriageway and its operational traffic on the setting of designated and non-designated assets. It identifies the benefits and harm that would be caused to assets in 18.342, and then says at 18.343 overall, whilst the harm to other assets does weigh slightly against the benefits of F10, the scheme is still considered to deliver a large beneficial effect. It's important to understand that's a large beneficial effect compared to the existing baseline. That's not compared to the promoted scheme. There are other matters that have gone into. We get to biodiversity, and F10 is identified as having a very large adverse impact in 1848 because of direct impacts on the River Avon SAC and the River Till and River Avon system SSSIs, which overlap with that SAC. There are impacts on county wildlife sites and hedgerows and woodlands. All of that is assessed, and we can see from that the sort of environmental impacts that have been identified by National Highways in relation to that particular scheme. And so the next document that I can take the court to is Rep 224, but I think you've already seen that. And I don't think I've got any additional places that I need the court to actually look at. But there are in that document, which you've got at tab 8 of the bundle, at page 2 of the first bundle, supplementary bundle, page 281, the similar assessment of very large adverse effect to route F10 as a result of the impacts on the upper Avon Narrow Chalk River Valley character area identified, and the biodiversity and water impacts that I've just taken you to.
Right, just pause,
are.
please. Which document are you looking at now?
So
that's Rep 224.
That's Rep 224, which you've already looked at.
Yeah, and the reference again, sorry.
The beginning of that, I think, is at it's supplementary bundle 1, tab 8, page 281.
Sorry, thank you. Do you want us to look at this?
I think that actually there is just one element I want to take you to, having.
And was this something that was submitted in May 2019 to the examination process?
Exactly, yes.
Yeah, okay.
Yes, deadline 2, as it was called. And if we turn to into that that document, the part that I wanted to draw the court's attention to are the summary tables at the end of page 286 and following. So this is in behind tab 8.
Yeah.
And there are a series of tables. The first of which is table 9.1, which sets out the client scheme requirements. So these are objectives for the scheme, and you can see what they are: transport, to create a high quality route, economic growth, cultural heritage, and environment and community. And the D options outscore F10 on every criterion apart from cultural heritage. And then over the page, there's a similar comparative table in relation to national policy. And again, the D options outscore 10 in relation to national policy. And then local policy is at 9.3, and I think it's fair to say that the position is more nuanced as between the various options in that table.
When you look at it, it's really because of the Stonehenge thing, and you look at the first 2 3s, because it does less damage to Stonehenge.
Yes, but in terms, as we've seen, of the other environmental effects and the wider impacts on the community, running connections into the local road network and the like, there were other issues identified. So there was, in my submission, considerable appraisal of the various competing options undertaken and provided into the examination. That continued past into the redetermination process. So the very next document in the second bundle, I think, tab 9. I've got the referencing right. Yeah, tab 9 of the second bundle, page 32. Is the
second bundle.
Yeah. This is the National Highways response to the state of matters and their position on alternatives. And if you turn to page 33, you can see the table of contents. And it starts with a section 2 in which the information previously put before the examining authority is identified, and that, you can see from page 36 onwards, includes the case for the scheme, the technical appraisal report that I've taken the court to, the scheme assessment report that I referred to, and indeed the environmental statement, chapter 3, which my learned Ms Grogan took you to on page 39, and the response to written questions, Rep 224, is referred to on page 40, paragraph 2.9.1. And then you've got an appraisal at that point of each of the options, including F10 at page 52, section 5, and an explanation is given in relation to that. We've got the Parker route at section 6, and so on. So all of the alternatives were addressed in that document as part of the redetermination process. So in my submission, it's perfectly easy to understand what the other environmental effects are, as referred to in DL, in the decision letter at 230. They are the ones assessed by the applicant with which the Secretary of State agreed in paragraph 229 of the decision letter. I'm going to move on from F10. back to the appellant's skeleton argument. So, having dealt with the three elements of ground 2 already, the only remains to identify the three factors which the appellant says were obviously material, but which were, it says, omitted from consideration.
What are you
by the
looking at?
Secretary of State.
Sorry, what are you looking at?
Paragraph 43 of the appellant's skeleton argument, which is at page 16 of the core bundle. These were the points. They say that the Secretary of State wasn't told that the scheme could result in the World Heritage Site being on the list in danger. I'll come to that in a moment. They weren't told that it said that the Secretary of State was unaware that F10 could be cheaper. My own friend Ms Grogan's already addressed you on that, and the judge addressed it in paragraphs 190 to 194 of his judgment. And then the reasons for the NPSNN review, again, Ms Grogan's addressed you on that, so I don't need to go back to that. Ground 3, of the burden of proof point, I've got nothing to add. Ground 4, fairness point. We've already seen from the Stonehenge Alliance's submissions post-quashing, we've got them at the Supplementary Bundle 2, tab 13, page 196 at paragraph 25, that the appellant's position was that the examination should be reopened or a public inquiry held, or that the DCO should be refused. His position wasn't that some other process should be followed.
Hold on. You've just been referring to page 196 of S2.
Yes.
And you're referring to paragraph
25. Yes.
Yeah, thank you.
In my submission in addressing the fairness issue, the judge correctly identified the question for the court at 114 of his judgment, which we've got at.
Could there have been a planning inquiry? Mr. Fleming accepts that you could have reopened the examination, although that seems to have been abandoned now. Could you have had a planning inquiry, and under what would the planning inquiry be held?
If as a matter of discretion, or if fairness dictated that a planning inquiry or a process akin to a planning inquiry was required, then in my submission it would have been perfectly possible to hold such a process.
So they must be thinking about having somebody like a planning inspector appointed to carry out some sort of inquiry. That's what it must be read as meaning, because it's not a planning inquiry under the 2010 rules. It's something like a planning inquiry.
All I've got is paragraph 25.
Yeah, well, yes, that's true. It's not your paragraph, yes. Sorry, yes.
In theory, it would be possible to run that sort of process if that's what fairness dictated. But that's the question, and that's where the rub is in this particular ground. In my submission, the judge at paragraph 114 of his judgment put his finger on the point for the court. That's at page 199, tab 16 of the core bundle. He says that whether the question was whether the examination had to be reopened in order to deal with the issues in the redetermination. He said that issue depends upon the requirements of fairness in the context of the scheme Parliament has enacted in the Planning Act 2008, the character of the decision-making body, and the issues which fall to be resolved and the representations made. We've got 2 points now, as I understand it from the appellants, that fairness required an independent appraisal and fairness required an expert appraisal. But those points are seemingly not framed in my learned friend's submissions to the court on Monday in the context of any particular issue that was raised. It wasn't said that this particular issue required independent appraisal and that particular issue required expert appraisal. And so we're, to some extent, looking at those issues, in my submission, on the wrong basis, because it's the issues that frame the requirement for fairness. In terms of independence, it appears to be suggested that inspectors should have been appointed, but of course it's established that in relation to policy determinations, such as the determination of planning applications and DCO applications, inspectors are not independent of the Secretary of State or the Department for Transport. And that was explained by the judge in his judgment at paragraph 110, which you've got at page 198 of the bundle, by reference to Lord Hoffman's speech in Auckland. And as I've already said, no particular issue has been identified that required independence anyway. In terms of expertise, there is no statutory requirement that a panel member or a single appointed person must be a planning inspector, nor that they have any particular experience or expertise. I made that submission to the judge in the court below, and you can see it from my skeleton argument, which you have in the core bundle at page 390, paragraph 5D. In any event, we have the witness statement of Mr Gilmore at Supplementary Bundle 3, tab 10, page 159, and paragraph 8, where he sets out the expertise available within the Department for Transport and within the team that was dealing with this DCO. And in my submission, the judge was correct at paragraph 117 of his judgment to note that the court's not been shown anything to suggest that the officials handling the redetermination were any less qualified than inspectors.
Can you just give me that paragraph number again?
Certainly, it's paragraph 117, core bundle 1, tab 16, page 199. In the skeleton argument, a number of points were raised about fairness. There was all of which I think have been addressed already, apart from the Beaker period remains point, which my own friend Mr Claimant kindly left to me, you'll remember, yesterday. That point relates to representations that were made in April 2022 by a body calling itself the Consortium of Experts. You don't have, I think, their submission in front of the court. But what we do have is the Secretary of State requesting a response from National Highways in Supplementary Bundle 2, tab 4, page 10. You don't need to turn that up, but that's where the request goes out for comment on what the consortium has said. And then we have the response, which is in Bundle 3. And that's Bundle 3, tab 28, 280. I would just like to take the court to that briefly, if I may.
Just let us get there then. Yeah.
And this is just an extract from the document, but you can see at the top of 280 that it refers to assets A, B and C. So there were 4 groups of assets identified. And the question was asked, have these been assessed? And what comment do you have? And so this is the response. And it says none of them are in the historic environment record, but 125, National Highways' position is that our responses to the examination already considered these, and our previous assessment still stands in references to earlier documents provided at deadline 5 were provided. And then it goes on to look at decisions about scheduling being matters for the Secretary of State. At 127, reference is made to consideration of the value of these remains when the environmental statement was compiled, and guidance was referred to, including criteria of national importance and the relevant historic England scheduling selection guides. And there's reference to the sites of early human activity. And then at 128, the Heritage Impact Assessment, page 483, was referred to, which assesses the remains within the footprint of the scheme, and that assessment follows the criteria for determining the value of heritage assets set out in the ES, in other words, the one that had regard to the criteria above, takes account the nature of the material and lack of association with subsurface features. National Highway's position, therefore, is that these archaeological remains are not schedulable, nor are they considered to be equivalent of significance to scheduled ancient monuments and of national importance. At 129, the value is identified by reference to what is already in the environmental statement. In relation to category D, they agreed that the Blickmead Mesolithic site was of high, in other words, national significance. That was the response. So there was a dispute then between National Highways on the value of these assets and the consortium. The Stonehenge Alliance came back to the point in their submission to the 3rd of August 2022, and you've got that at the second supplementary bundle, tab 14, page 289, and at paragraph 2.7.1.3, the Stonehenge Alliance assert that National Highways continues to fail to recognise that the assets A, B and C are of equivalent value to scheduled ancient monuments.
Are these
Can you give that
references
reference?
in, sorry,
Just the references again.
Yeah,
are they in your skeleton? Because you've lost me about 2 minutes ago.
did I? Sorry. I don't think they are in the skeleton because I think...
Right, the last...
So the last reference is the Stonehenge Alliance position in August of 2022, which is in the supplementary bundle 2, tab 14, page 289, and it's paragraph 2.7.1.3.
Yeah.
And the previous reference was the National Highways response of June 2022, which is at supplementary bundle 3, tab 28, page 280.
200.
280 is where the document is.
FB3 280, yes?
Yeah.
And on page 289, SP2 14 289, paragraph 2.7 point what?
1.3.
Thank you.
2.7.1.3. So the position was there was a disagreement as to the value of those assets for the Secretary of State to resolve, and he resolved in the decision letter at paragraphs 95 and 96, which you've got at tab 36, page 616.
Hold on.
So, in my submission on behalf of National Highways, the judge's conclusion at paragraph 137 of his judgment was correct. The appellants have failed to identify any issues which, as a matter of fairness, were required to be dealt with in a way that could not be addressed by written representations to the department and questions from the officials.
But you're going very fast,
You are.
which is quite difficult for us.
I'll try and slow down, but I've got my eye on the clock.
You've made, yes, but we do need to record your submissions,
You do.
and you've just made one, and I'd like you, if you wouldn't mind, to give it to us again at
Yes.
dictation speed. please.
Of course. So the point I was making about the beaker remains was that there was a disagreement between the consortium on the one hand and National Highways as to the value of those assets.
Yeah.
The consortium was saying they were of national value, and National Highways were saying no, they weren't.
Yeah.
The Secretary of State had to resolve that dispute, and did so in the decision letter at paragraphs 95 and 96 on page 616 of Full Bundle 1.
Just testing that submission, if I may. The dispute is, are they equivalent to a scheduled monument or not? And what this actually says in the last sentence on 96 is, the Secretary of State is content that these assets have been appropriately considered. I don't know whether that is resolving, are these beaker things very important, or are they not very important, Or is it just a methodological, I'm quite happy that they looked at these very carefully? Or does the latter necessarily mean, and therefore there's nothing to doubt your conclusion?
It's the latter.
Oh.
in my submission.
Right.
And so the other matters that identified in the section of the appellant skeleton argument relating to fairness were alternatives, traffic forecast, groundwater and the business case. All of those matters have already been addressed by my own friends. I'm not going to take the court's time on that. Where it leads in my submission is that the judge's conclusion at paragraph 137 of his judgment was correct, namely that the appellant has failed to identify any issues which, as a matter of fairness, were required to be dealt with in a way that required reopening and which could not be properly addressed by written representations to the department and questions from officials.
So in other words, your submission is there's no reason to supplement the statutory procedure?
Indeed. In terms of the risk of delisting, I've got...
Hold on.
So this is ground 5.
Right, so ground 5. How many submissions do you have on ground 5?
Not very many, and then I have barely any after that. So I've got about 5 minutes left.
So what would help us, I think most, certainly me, would be for you to express the submissions as submissions.
Yes.
Make sure that we get a note of them, and then amplify if necessary by any salient references.
So the first point I make is that the potential for the World Heritage Site to be put on the list in danger was not an obviously material consideration. And the basis for that submission is that the assessment basis for being included on the list in danger is different from the assessment basis for being removed from the list. And the judge explained that in the judgment at paragraphs 212 and 213, tab 16, page 219.
Sorry, I missed that again, I'm so sorry. Which paragraph, 2 and 3?
212 and 213. He identifies the basis for determination that a site should go on the list in danger, and the basis for determining that a site should be removed from the list, namely that the characteristics which determined inscription have been lost. So the two tests are different. That's the first point. The second point is that being placed on the list in danger doesn't change the status of the World Heritage Site. It remains a World Heritage Site, and so its status for decision-making purposes does not change because it is on the list in danger.
Yeah, but the practical point is, if it's put on danger because you're running a tunnel up the barrow or through the barrow, and you go ahead and do the barrow, then as Night Forest Day, it'll move from the one list to the other.
Once you're on the list in danger, then that's a step towards the consideration of whether, if the scheme goes ahead, the characteristics which determined inscription have been lost. It's only once you've done that determination, decided yes, they have been lost, that the World Heritage Site is removed from
My
the
last
list.
point remains, which is by taking the first step, you are a step closer.
Yes, indeed.
Is it sequential In other words, do you have to go through step 1 to get to step 2, or can you go straight to step 2?
No, you have to do step 1 to get to step 2.
Where does it say that?
The operational guidelines say that.
Let's look
Indeed,
at
that was my my learned friend's submission to you in her presentation too. I think we're
Right. Well, you've got the reference there then.
I think I
If you
might-
haven't, don't worry, we'll find it later.
I'm afraid I don't have that because I've just done it by reference to the.
All right, so that's your
to the
second
judge.
submission.
Yeah.
What's the next one?
And so, what that means is that when the Secretary of State appraises the risk of delisting in the decision letter at paragraph 101, that appraisal is founded upon an assumption that the site is already on the list in danger.
I don't understand that. I'm very sorry. Just as either as a matter of language or logic, it makes no sense to me at all.
Where the Secretary of State in the decision letter appraises the risk of delisting, he's undertaking a consideration of a risk in relation to a step which can only arise if the site is already on the list in danger. You put a site on the list in danger, and then there's a process under the guidelines that leads to consideration.
You're saying, I think, that it's inherent in the consideration of the second step, that the first step must have been gone through.
Exactly.
That can't.
And that's whether that's right or not. That's your submission.
That's my submission.
Okay. It's your submission.
And so, in my submission, the point about needing to be aware of the risk of going onto the list in danger goes nowhere, particularly because the basis for removal from the list raises different considerations from the considerations that put the site on the list in danger. The decision to put a site on the list in danger is taken without any assessment of whether its characteristics, which determine inscription, have in fact been lost.
Why can't you just assess the risk of losing status before you've gone onto the list? You can perfectly properly say, if we do this, there's a risk that stages 1 and 2 will follow. You're not assuming that stage 1 has already happened, are you?
It would have been perfectly possible for somebody at the DCO examination to have conducted an assessment of whether the characteristics for which determined inscription of the World Heritage Site would be lost if the scheme went ahead. You could try and do that. It wasn't done by any party. No such appraisal was before the Secretary of State, and it's not been done by the World Heritage Committee or any of its advisors. There is no such appraisal. And indeed, my learned friend made the submission to you, I think on Monday, possibly Tuesday, that couldn't be done until the point at which the road was actually being built. In my submission, that's right, not least because the DCO is to some extent an order which creates a sort of outline scheme for the road. You'll see from the judgment at paragraph 221 that the DCO contains articles which allow more detailed designs to come forward in a detailed design stage.
It doesn't matter. It's not the design, it's where it's coming out of the ground, and it's coming out in the middle of a mound.
Yes, but the design can be changed. You could,
What? By adding 1.6 kilometres, is that a design point?
no, so, certainly not. But there is flexibility in the DCO itself, and it's only once you've got the detailed, the final version of the scheme that's to be built, that you could actually conduct the appraisal of the impact of that scheme upon the characteristics which determined inscription.
Can you indicate to the court, Mr. Taylor, what is the, if you like, the deviation that's possible once the DCO is approved, in particular at the western end, where the road breaks surface in the midst of a number of burial mounds? I'm
not able to take the court to that because it's a very, very detailed question. The the DCO has many.
Yes, but are we
Maybe
speaking
not.
about hundreds of yards, tens of yards, or what?
There are many different design options. One could, for example, produce a cantilever from either side over the top of the road that doesn't necessarily meet in the middle, so you don't have an entirety cut and cover. There are all sorts of design options that could be considered that would potentially reduce the impact of seeing the cutting. These are the sorts of matters that are currently being considered.
Going back to your main submission, I understand what you say, that there's a listing process and that's all about one thing, and then there's going to be, has it really lost the characteristics? Is this no longer Stonehenge as we know it and love it? But isn't the reality, for ages, the World Heritage people have been saying, if you put a tunnel where you're going to put it, right in the middle of the archaeological remains, that is something we think is problematic and don't approve. And the listing is just you're 2 steps closer to the abyss. Go any further and you'll be over the edge. And isn't it just a question of, did the Secretary of State properly look at the risks that the status would go, rather than the technical steps by which that status would go?
Yes, in my submission, that's exactly.
Where does he do that?
But well, he looks at paragraph 101. He explains that the process is via a separate system.
Yes, but that doesn't really make any sense, does it? Because, yes, it is a separate system in the sense that the person who will ultimately decide whether to take it off the list has got to be the World Heritage Commission.
Yes.
Because they are the people who put it on the list and maintain the list.
But it's more than that, because they're not just the person that makes the decision. There has to be an appraisal of the scheme against the criteria, against the test of whether or not the World Heritage Site has lost the characteristics which determined its inscription. That's not been done. There's no evidence before the Secretary of State that identifies what the outcome of that process would be. There's nothing to indicate even a likelihood.
But you can never have that until they take it off the list. Therefore, you build something, you can demolish, you can run the road right between the stones. And you'll say, well, I'm terribly sorry, they've never yet assessed whether putting a 4-lane highway through the middle of the stones involves a loss of status. But I mean, surely it's Dyke Forest Day if they did that. But you'd lose the status, and then the Secretary of State would have to decide, should we lose the status?
But my Lord, if the position is that the Secretary of State didn't have the appraisal against the criteria which are applied, and the World Heritage Convention, the World Heritage Committee and the advisory bodies haven't undertaken such an assessment either, Stonehenge Alliance haven't provided one, there's nothing before any of the decision makers, either on the DCO or indeed at an international level, which can apply, which actually seeks to apply the test that's in the guidance. If there's no evidence, the Secretary of State has to take a decision on risk in a situation where there's a separate process to be undertaken, and when where there's no evidence that assesses the likelihood of the particular test being met or not.
But doesn't he have to decide, or does he have to decide, whether status will be lost if he builds this tunnel? And I know we'll never know whether status will be lost until it's built and the World Heritage Organisation does it. But if you're thinking about doing something, take it to criminal offence. If I hit you in self-defence, am I going over the top by hitting you 5 times? You've got to predict. You won't know whether it's unreasonable force until you've in the dock and the jury says, yes, we never did like him. So you've got to make an assessment, haven't you, about if I let this tunnel go through the mound, will it result in a breach of Article 4? He may be wrong because he may get away with it, but doesn't he have to decide it?
In my submission, no. Because what there is at the point of the decision is a risk, nothing more. And indeed, the Stonehenge Alliance were not saying anything more than that there was a risk of delisting.
But how does the separate process decide? Because the separate process isn't a separate process, it's a different process for a different purpose, because they will be deciding to keep you on the list. But you've got to do something different, not you the Secretary of State. They've got to decide whether to run that risk And that's the process that they're dealing with. Should we put it through the Mount? Because
Yes.
there is a separate process which has consequences.
Yes.
Not that there is a separate process and that will deal with the risk that we're assessing.
The Secretary of State has to decide what weight he gives to the risk. He's taken the risk into account. There's no doubt about that. The challenge here in relation to delisting, apart from the latest point about the materiality of going on the list in danger, which I've already addressed, that the risk of delisting was taken into account by the Secretary of State, and the challenge is a rationality challenge to the judgment that it should be given no weight. That's the context.
You rely, as does the Secretary of State, on the last bullet point in paragraph 101.
Yeah.
Is that right?
Yes, indeed.
And all of it, including the bit at the end, he just doesn't think there's going to be a breach.
The sentence is written in a way that requires care in its reading, but as we established yesterday, I think there were either 3 or 4 considerations wrapped into the same English sentence.
Yes, I don't demur from that.
And
that approach.
I think it was being submitted, or the gist of what was being submitted seemed to be that because the Secretary of State had included in that list at least that this would not lead to the UK being in breach of its World Heritage Convention obligations, that there was inherent in that an outbalancing of the risk of delisting. I think that was really the gist of it.
Yes, I think that.
Now, is that your submission, or do you make a difference?
Yeah, that is my submission.
Is there anything to add to it, really?
No. I think the only point that I would potentially labour is that the steps that are yet to come. So there's the design to be finalised, and there is still to be undertaken any kind of assessment of the impact of that finalised design upon the characteristics which determined inscription. It's only if that assessment identifies that those characteristics are lost that delisting would occur. So that's important, I think, to understand when it comes to look at the rationality of the judgment as to the weight given to the risk.
Well, one point on which you could give us some help, I think, is on the meaning of the last, or your reading of the last of those 4 points in that final bullet point in paragraph 101, which refers to the applicant working with advisory bodies when constructing the proposed development. Does that embrace your concept of detailed scheme design?
Yes.
Is that the point?
That's exactly it. And indeed, that's how the judge in the court below read that paragraph too, as you would have seen from the judgment at paragraph 221.
That doesn't seem to suggest that there's much room for manoeuvre, if I can put it like that, with the alignment and the location at which the road breaks surface.
I'd have to take detailed instructions on that.
I mean, it seems that it may be pertinent to the whole point you're seeking to address.
I think my point doesn't need to go that far in terms of the detail. My point is just that there is still uncertainty in the process that leads to the assessment as to whether the characteristics would actually be lost.
But leaving aside the uncertainties that you referred to, as things stand, with the design of the sort that we're looking at, not this design of a sort that we're looking at, the Secretary of State has taken the view that at the end of the day, when push comes to shove, although it's going to come up in the middle of the barrow, the overall characteristics will not be so impacted as to be a breach. It may turn out to be wrong, and we may lose the status, but that's what he thinks. Is
Yes,
that it?
that's the judgment, and indeed that's a judgment that my clients disagree with. My clients say that actually overall there's a benefit to OU goods.
And you might be right, the Secretary of State might be right, or you might both be wrong, and we might lose it.
Well, it's like they're different characters. It's a different consideration, because the consideration of whether the characteristics for inscription are lost is a different process from assessing the impact of OUV.
Stakes are quite high, aren't they?
The stakes are indeed high, which is why we've been through this exhaustive process and indeed been through a long examination as well, and why many thousands of documents have been generated by the scheme for consideration by the Secretary of State. These schemes are always complicated.
Right.
Is there a way of going back, saying that you get to Delhi and they say this is a tunnel too far, as opposed to a bridge too far? Can you undo, not you, can the Secretary of State undo the DCO, or was this it, basically?
Well, for the project to go forward, it would have to be funded. There are decisions yet to be made about that, as I understand it.
Oh, I see, so they could cut you off at the funding point.
That would be one way, probably the simplest. In terms of actually revoking the DCO, I don't see that is
A possibility.
It is a possibility.
No.
Right.
In terms of the World Heritage Convention point, you've got
this is ground
ground 6.
6, yes.
You've got my submissions in paragraphs 52 to 83 of my skeleton argument.
How's 50?
52 to 83.
Thank you.
I'm going to ask you to take those as read, if I may.
Yes.
I'm not going to add anything to those, and I've got nothing to add on ground 7. Right. My lords, I've strayed beyond my time.
But we've asked you a number of questions, which we've needed to ask. Thank you very much, Mr. Taylor.
Thank you.
Mr. Howard, can you fit in some submissions before 1 o'clock?
I can, my lord. I'll stop at 1.
All right. Thank you very much.
This piece. Rearrange the furniture. And my lord, can I pass up an extract from the Vienna Convention, which deals with my Lord Justice Lewis's question about what documents may be looked at in interpreting a convention.
Thank you so much.
So it's.
Thanks so much. Where do you want us to go?
With the operating
Probably
guidelines.
best. I was going to suggest putting it at the back of the authorities bundle, which is tab 62.
Are we coming to it quite soon?
I'll come to it after lunch, I think.
Okay. Right. Well, we'll put it in the folder now.
Yeah. And
At the end of the authorities.
yeah, Malone Friend has seen.
And they have the 45th decision, which we said we'd hand up yesterday.
Right.
12
Oh,
to
yes.
committee.
Yeah.
All right. Where's that going to be put?
I think the most sensible place, my lord, would be at the back of supplementary bundle 3, because that's where decision is.
Right. So the Vienna Convention is going in at the very end of the authorities bundle, volume 3. Thank you very much. And then the decision 45 document is going into folder
S3. Supplement 3.
Yep. We've already got 46 there. So is it going to be too complicated to try to interleave it? Right.
My lord,
Mr. Howard.
in a nutshell, Historic England's position is that the Secretary of State's consideration of the risk of delisting was lawful, and what we want to do is to assist the court on the World Heritage Convention context for that. And the second nutshell point, my lords, is that Articles 4 and 5 of the World Heritage Convention allow a balance to be struck, and they do not necessarily prohibit schemes which cause harm to the OUV.
Do not necessarily.
So it's a matter for, I go on to explain, it's a matter for the state's party's judgment. My Lords, Historic England come to this as the advisor to the state party on the World Heritage Convention, and also having been involved in trying to resolve issues at Stonehenge for many decades. The roads which run through the World Heritage Site are and have been always acknowledged as a problem. So my Lords have that in the statement of outstanding universal value, which is at SB3. We don't need to turn this point up. SB3, page 237, as causing harm to integrity. Now, my Lords, it's helpful to go to SB3 for the next reference I want to turn to, which is to look at the State of Conservation report, which is in SB3, page 245. It says a little bit about the evolution of that. So this is the 2022 UK report. And my Lord, it illustrates how solutions have evolved. So if we look at the bottom of 245, UNESCO, so World Heritage Committee, first expressed regret in 2007 that no progress had been made in the implementation of the scheme for a 2.1 kilometre tunnel. That's what was being talked about 17 years ago. We now have a proposal for a 3.3 kilometre tunnel. And my Lords, I know there's been some discussion of tunnel lengths, but we find the 3.3 figure, first of all, in this document, page 247.
We have to be careful that we're not comparing oranges with apples. 2.1 kilometre tunnel canvassed in 2007. Did that include, that 2.1 kilometres, did that include the portals and cuttings or not?
These are all tunnel lengths.
These are
these are 3.3
merely tunnel length.
These are tunnel lengths.
So 2.1 plays 3.3 is
3.3. So it's got longer.
So does it matter? I mean, just if it doesn't come up in the middle of the barrow, but comes up a little bit off centre, if it's still coming up through the barrow, it's not the length of the tunnel, is it? It's where it comes up. So knowing that it's a bit longer, does it tell us anything without further inquiry?
A lot of the debate has been about the length of tunnels because, of course, what that does do, the longer the tunnel is, the more it removes the road from the surface of the 303.
Yeah.
So in that sense, the longer the tunnel, the better.
Well, I understand that the longer the tunnel, there's less visual impact on Stonehenge. There'll be fewer cars going up along and you'll have a bigger vista. But I thought, from what had been said on Monday, that the problem wasn't so much the impact on what's called the henge, the stones, but that part of the site of the whole included these beaker barrows, or these barrows, and in a tunnel that's less than a certain amount will come up in the middle of the barrows, in the middle of the site. And to say, therefore, it's a bit longer doesn't really help unless it's so long as to avoid that problem, if you follow me.
Well, my Lords, let's just track back to what we have. What we have on the site, and we've listed some of the numbers here, is a site with an immense number, well over 100 monuments, scheduled monuments within the Stonehenge part of the World Heritage Site. One of those is the circle, which is what people generally think of as Stonehenge, but it's a far larger complex and a far larger landscape. The World Heritage Site itself, which encompasses that, is the area which we've seen for the lower part of it in the various options drawings, and goes up to include the Avebury Henge and Silbury Mound and so on. So all of that designated area is a World Heritage Site. Within that are the monuments. This tunnel manages to avoid all the monuments, which, given the context of that landscape, is actually quite a significant engineering achievement to do that. What there is this debate about the various options. What I'm doing is illustrating that those options have changed, and indeed a few years ago the UNESCO view was, in fact, there's a shorter tunnel was what they considered acceptable. The debate we have primarily with UNESCO at the moment is about whether the tunnel should be longer than the 3.3 kilometres which is being proposed. My Lords,
Well, we've got to 1 o'clock.
we've got to 1 o'clock.
And before you get into your stride, perhaps we'd better pause.
Indeed, my Lord.
And, start again at an appropriate time. I'm going to suggest 2 o'clock, unless anyone suggests to me that we're going to be wiser to have a shorter break.
Well, my only observation, my Lord, is what we've got left this afternoon. So
Yes.
the timetable that we were given a couple of weeks ago now from the court gave us replying from 2:30.
That's right.
We overshot by 15 minutes, so happy to swallow that up, but that's what we're working on.
So, Mr. Hussey.
My Lords, I'll stick to within 3/4 of an hour if I can do it in less.
So we can come back at 2, not 1:45.
Happy to start at 2, my Lord.
Everyone happy to start at 2? We'll start at 2. Thank you.
Don't rise the tables.